cryptographic communications. Can you get software patents on different inventions related to cryptographic communications? And the answer is yes. In the United States, you can. Today, I'm actually going to go over an of a type of cryptographic technology that is found to be patentable, or has been found to be patentable according to the United States Patent and Trademark Office. And I'm going to share my screen here. All right. So to talk about this, we are going to be talking about one of the big issues that we have with software related inventions and whether it's considered abstract. When you look at a software patent, the most important part of a patent application or a patent is the claim section. That's actually what the applicant or the inventor believes is the most important part, or the metes and bounds of their invention. One of the big challenges that software patents will have is that whether or not it's quote unquote an abstract idea. Okay. And the USPTO has a very specific test as to whether or not software is patentable or software related inventions is patentable. Today, we're going to be talking about this particular claim. This is actually an example that was put out by the USPTO, and we're going to talk about cryptographic communications. So this claim is based on an invention that's a method for establishing cryptographic communications using an algorithm to encrypt a plain text into a ciphertext. And this claim in particular was found to be patentable on patentable subject matter under 35 USC 101, which is really all about whether or not this claim is abstract. Okay, whether it's quote unquote too abstract to become a patent. And there's a few different steps in order to determine whether this claim is patentable. The first step is step one, which is the claim a process, machine, manufacturer, or composition of matter? And because it's software, it's a process. So step one, it's a process. So then after step one, you have to go to step 2A prong 1. Just as a side note, we actually will be going to step 2A prong 2 as well, and then a little bit about step 2B. But this claim, as we can see it here, is a method for establishing cryptographic communication between a first computer terminal and a second computer terminal, comprising receiving a plain text word signal at the first computer terminal, transforming the plain text word signal to one or more message block word signals, MA, encoding each of the message block word signals, MA, to produce a ciphertext word signal, whereby, and then they gave a formula, and then they actually define different elements here, and then they say transmitting the ciphertext word signal to the second computer over a communications channel. So if we go to step one, we know it's a process. So the process and the flow chart for determining whether or not this is an abstract idea, we have to go to step 2A. And step 2A prong 1, step 2A prong 1, that you have to know, does the claim recite an abstract idea, law of nature, or of natural phenomenon? And in many cases, and in this particular case, for software-related inventions, you have to go through a set of groupings. And one of the groupings that they talk about, actually, a list of different things, is mental processes, organizing human activity. You see organizing human activity in a lot of like medical records type, medical record type software patent applications, commercial, like in legal interactions, managing personal behavior. Those are kind of groupings that you would typically would see when you're talking about abstract ideas. In this particular case, and in cryptography, in step 2A prong 1, the abstract idea in this case includes mathematical formulas and equations, which it does. It includes a mathematical formula and equation. So because it does include this mathematical formula and equation, you actually have to move on to step 2A prong 2. And to be more clear, the encoding step right here, the encoding step has this mathematical formula. So we have to go to step 2A prong 2. And step 2A prong 2, actually, you have to determine whether or not this claim recites, this claim is actually integrated to a practical application. And what does that mean? That means that you have to determine whether or not the combination of additional elements in the claim, such as the formula, integrates into a practical application. And in this particular case, it does. And the USPTO has basically gave us guidance that says, in this particular case, the combination of these different elements that use this mathematical formula and calculation actually limits the specific formula to a practical application of transmitting ciphertext word signals to a computer signal over the channel. So they say that, first off, they talk about receiving this word, okay, this plain word text, transforming the word text. And not only you have this encoding step, but you also have transmitting the ciphertext to the second computer signal over a communication channel. And the USPTO has provided guidance that says, because you're actually doing these steps in addition to this mathematical formula, that it is actually considered patent eligible under step 2A prong 2, which is great. Okay. So they said that they also noted that because it's considered, it's called well understood routine and conventional subject matter, you still can actually integrate it into a practical application. So even though they're receiving the signal at the first computer, transforming it, and then transmitting the signal transform to a second computer are described in the background as being conventional, that does not evaluate whether the additional segments are conventional to determine whether they're an abstract idea and integrated into a practical application. So even though you have these additional steps, and even though it may be well understood routine and conventional, you still can actually integrate that into a practical application. That's because it's actually even though these steps of transmitting may be well known, you can still integrate it in a practical application using this complex formula. So that said, what does that teach us? Well, that teaches us that when we're drafting claims and we're filing applications, we have to consider the details that we're putting into the application in order to give the highest probability of being able to get a patent for our clients. Also, if you are working in cryptography, even if you're using a formula, the formula by itself may not be considered patentable. If you're using this particular formula as a process, actually, that may not be considered patentable. So the second thing is, I highly recommend you're doing a search before you actually file a patent application, a patent search before you file a patent application. And the reason why you want to do a search is because even if it's not abstract, even though it's not abstract and you may be entitled to, it may be a patentable subject matter, you still need to know whether it's new and non-obvious to get a patent. So even though this is one major hurdle, which is the patentable subject matter concept, you have other hurdles to consider with patentable subject matter related to cryptography and any other software or other type of technology. So I hope you found this example interesting. In short, just remember to go through the process and the steps 1, 2A prong 1 and 2A prong 2. Hope you found this interesting. If you have any questions on software, cryptography, give us a call. My name is Derek Fahey. You can find me on Instagram, Derek Fahey PA. That's also my handle for TikTok, and you can also find me on YouTube, and www.plusfirm.com is our website. Please like and subscribe to the channel if you enjoyed watching the video. And thanks for watching so much, everybody. Have a great